to another episode of Teen Scene. I'm your host, Ariel Brown. I have a great episode for you today. We're going to be going back to School Court TV. But I also want to let you know about some programs for young teens that are coming up in Maryland. So don't go away. We have a great show for you.
Coming up on School Court.
Welcome back. I'm Ariel Brown, and as a teen, I feel that I can contribute a lot to society. I love music, I love to sing, I love to be happy, smile, have fun in life, have a great time, just be a great help to people who are less fortunate than I am, and basically just do what it is that God has planned for me. Today, we're going to take you to School Court TV, where kids are learning how to deal with real life situations. So let's go see what's going on at School Court TV.
Plaintiffs, can you please identify yourselves? Counsel for the plaintiffs.
I'm Attorney Carrie O'Dare, representing Jack Barrow.
I am Princess Green, I'm the co-counselor for Mr. Jack Barrow.
All right, thank you, sir, ma'am. And representing the defendants.
I am Attorney Jonathan George, and I'll be representing Mr. and Mrs. Morris.
Okay, and can you identify the individual with you?
Here we have Mr. Morris.
Okay, and is Mrs. Morris here?
No, sir.
Okay. All right, thank you. I've reviewed the pleadings in this matter. This is a complaint that is based upon a allegation of lead poisoning, and there are two counts that have been alleged. One is based upon negligence, and the other is based upon a violation of the Consumer Protection Act. What I'd like to do is proceed with allowing each party the opportunity for opening statements, allow their case in chief and rebuttal, and because we do have a time limitation today, we're going to limit opening statement to 3 minutes per party, 6 minutes on the case for the argument, and the opportunity for 2 minutes each for rebuttal. Counsel, are you all satisfied with that time frame?
Yes, Your Honor.
Okay.
Yes, Your Honor.
All right, with that, we'll go ahead and proceed. Plaintiff, it's your case.
We're here today on very, very tragic circumstances. Now, young Jack Barrow has been permanently, severely damaged neurologically, developmentally, in every type of way because of lead paint poisoning. Lead paint poisoning he received as a property that Mr. and Mrs. Morrison owned. Due to their negligence, Jack Barrow will never be a fully functional member of society. He will always be behind, always have problems that he can't control due to the lead paint that he inherited as an infant. We're here today requesting $5 million for damages, costs of attorneys, and negligence from the defendants, Mr. and Mrs. Morrison. We hope that in doing so, we will give Jack a chance to have a somewhat normal life.
All right, thank you. You do have another minute and a half, so is that something you wanted to add, Mr. Gregg?
Yes, Mr. Green.
Green, I'm sorry. Go ahead, sir.
Thank you. Hello, I am Princess Green. I'm the co-counselor for Mr. Jack Barrow. In addition to what my co-counselor states, Judge, I would like to add some additional facts. Ms. Barrow was pregnant in the house with chip paint, which has a direct effect on the unborn child, Mr. Barrow. People have reported seeing the young Mr. Barrow in 1992 crawling and chewing chipped paint. Since the house had paint that was chipped, he and his mother inhaled the dust. In no time was there an inspection by the health department or the landlord, Mr. and Mrs. Morris, after countless complaints to Mrs. and Mr. Morris. In 1992, federal government submitted Title 10 Resident Lead-Based Paint and Hazard Reproduction Act. Thank you, Your Honor.
Okay, thank you, Mr. Green. Mr. George, 3 minutes, please.
Your Honor, all too often in today's society, Your Honor, landlords have been accused repeatedly for young children with lead poisoning. But, Your Honor, what is not distinguished, Your Honor, is Do the children have lead paint poisoning, Your Honor, or is it lead poisoning? You see, because lead poisoning can come from anywhere. Lead poisoning can come from mud. It could come from lead paint that was on children's toys. It could also come from jewelry that the children may wear. In addition to that, there's also lead dust, Your Honor, that the children can inhale. If a child touches any furniture that has lead dust on it and puts his fingers in his mouth, the child can then be contaminated with lead. So, Your Honor, today we should distinguish. There should be evidence presented today to distinguish whether young Jack Sparrow obtained lead paint poisoning or lead poisoning, Your Honor.
Okay. Anything else, sir?
No, sir.
All right, thank you. Okay, plaintiffs, it's your case. Ms. O'Dare, Mr. Green. We're going to limit you to 6 minutes in the presentation of your case, please. Ms. O'Dare, you're going to begin. Go ahead.
All right. Your Honor, it has been determined that Jack Sparrow does have lead paint poisoning. Not lead dust poisoning, not lead poisoning, lead paint poisoning. When Jack was living at the Morrison's property, he ingested paint chips and paint dust containing lead. As a result, he was in contact with lead paint and was given lead paint poisoning. By the Morrisons' failure to upkeep control and let the Sparrows be aware of the hazardous living conditions in which their home contained, they not only broke their own contract but violated the Maryland Consumer Protection Act. And they also failed to stay in compliance with the Baltimore City Housing Code. Jack Sparrow has lead paint poisoning. Not any other type of lead poisoning, lead paint poisoning. So, the counselor's defense of any type of lead poisoning is incorrect. It is lead paint poisoning.
Okay. Ms. Green, anything you want to add?
Yes. Your Honor, the plaintiff is now 20 years old. Where most young men are learning, growing, working, and experience life, Mr. Barrow is living a life of uncertainty, a life of anger, illiteracy, and confusion. And at times, he asks himself, why? The only answer that he comes up with is because my mother cannot afford to live the American dream, like you, Your Honor. Because Miss Barrow can only afford a basic roof over her family and rent it from a landlord that basically gave her that only roof, Mr. Barrow suffers, and Mr. Barrow will suffer for the rest of his entire life. October 10th, 2010, Baltimore City awarded a 23-year-old woman nearly $23 million on circumstantial evidence because the property at 3223 Cherry Lane Road had been demolished before it could be tested for lead paint. The judgment was for $825,000 in economic damages and $20 million in non-economic damages. Despite the lack of evidence, Carter was seen with chipped paint in her mouth as a child. Thank you, Your Honor.
Okay, well, let me ask you some questions. Do we know, first of all, who the owners of the property are in question? And the address is where? Where are you alleging that the lead paint was contained?
Address is 11415 West Fayette Street, property owned by the Morrisons.
Okay, and are we stipulating, counsel, that they are in fact the owners of that property?
Yes, Your Honor.
Okay. All right. And you've indicated lead paint poisoning. Were medical records submitted? Have we reached stipulation that there is lead poisoning?
I'd like to present the court with that medical record.
Okay. Counsel, you've had an opportunity to review that?
Yes, Your Honor.
Okay. Any objections to that admission?
No, Your Honor.
Okay, so admitted. Do we have any evidence of any lease between the Morris family leasing the premises?
We do, Your Honor. I'm just trying to find it. Here it is.
Okay, counsel, have you had an opportunity to review the document?
Yes, Your Honor.
Are there any objections?
No, Your Honor.
All right, hearing none, same is admitted. Okay, when is the lease date?
The lease date was for about almost a year from
When
the
did it start?
1990.
When in 1990?
It started around, I believe, May.
Okay, May of 1990. And how long was the residency?
About 9 months.
Okay. And when did the plaintiff vacate the premises?
When the child was about a year old.
Okay, and when was the child born? I think that was in your pleadings. May of 91.
Yes.
Okay. So you're presenting evidence that the lease was entered into in May of 1990. Child resided there for approximately 9 months.
Yes.
And the child was born in May of 91.
The child was living at the house. The lease must have been in 91 then.
Okay.
Sorry for my confusion.
That's okay. And when was this action filed in court?
This action was filed about 19, 20 years after the moving of
I need
the...
the exact date. When was it filed? Do we know that?
No.
Okay. Okay. Any other information that you want to present to me at this time?
Not at this time.
Farzan Mohammed, visionaire and creator of School Court TV. Ambition of this show, to create and develop leadership in our youth through researching facts, developing and presenting those facts effectively in written and verbal form. To quote Mr. Mohammed, to have our youth see any situation from inside the box, outside the box, and around the box. Make things happen. Take leadership seriously. Do this through School Court TV.
If you're enjoying the show and you want to become part of School Court TV, all you have to do is audition May 19th at Marley Station, or you can log on to schoolcourttv.org.
The evidence, Your Honor, is very obscure. One person says that they saw a baby 20 years ago eating lead paint chips.
Well, hang on, Mr. George. This is not your time for argument, closing argument. This is your time to present any evidence in this case that you want in defense for your client.
Okay. Well, I'd like to present 3 exhibits to the court.
Yes, sir. What's the first document, sir?
Exhibit number 1 is from the U.S. Consumer Product Safety Commission. And what this shows, Your Honor, is information about lead paint and lead paint poisoning. And it also says that ingesting and inhaling lead dust that is created as lead paint chips, peels, or deteriorated surfaces can also give the child lead paint poisoning. However, Your Honor, the property underwent a yearly inspection done by the city. And the city has no records of chipped or peeling paint. If the city did see chipped or peeling paint, Your Honor, they would have immediately took pictures and they would have had records of lead paint on the property, Your Honor. However, there is no record from any inspections, Your Honor, that the city has done. If the city found lead paint or just chipped or peeling paint on the property, they would not have issued the use and occupancy permit that my client obtained.
All right, you've now presented a document which we're marking as defendant's exhibit number 1. Plaintiff's counsel, have you had an opportunity to review this document?
Yes, Your Honor.
All right, you're attempting to move this into evidence at this time, sir?
Yes, sir.
Are there any objections?
No, Your Honor.
All right, hearing none, defendant's exhibit number 1 is entered. Thank you, sir. Let me ask you, do you have any evidence? All right, go ahead, finish with the case first. Do you have any other documents, sir?
No, I do not, sir.
Do you have any evidence of a lead paint certificate that is required in Baltimore City?
No, Your Honor, because this was actually in 1989 when my client acquired the property. The rules and regulations were vastly different back then as to what they are right now.
I see, very good. Okay, sir, you have additional time. Is there any other evidence that you'd like to present at this time in defense of your case?
No, Your Honor.
Do you concur as to the time frame in which the child resided at West Fayette?
Yes, Your Honor, I do.
Okay. All right, thank you, sir. I've heard all the evidence, and let me just clarify. Plaintiff's Exhibit number 1 has been the medical records of the child stipulated and entered into evidence as Exhibit 1. Plaintiff's Exhibit 2 was the lease, and Plaintiff's Exhibit number 3 was the inspection history. Is that right? What was your Exhibit 3?
It was saying that the house was never tested for lead paint.
Not tested for lead paint, right, thank you. Okay, at this time, I've heard the evidence in the case, and each party will be given the opportunity for 2 minutes for closing argument or any additional rebuttal that you wish to offer. And plaintiff, you had the burden of proof, so we're going to allow you to go first. Go ahead, please.
Regardless of whether the rules 20 years ago said that the Morrisons didn't need to acquire the correct certificates or papers, times have changed, and they still haven't there's still no evidence that they have gotten these certificates, papers that are needed. So this goes to show that they are a non-credible rental service. They do not have the consumer's health as a priority. And regardless of whether that was the rules at the time, Mr. Morrison still inherited the problem when he bought the property. So he could say that, well, I didn't paint the walls that had the lead paint in them, but it does not matter. Once you buy the property becomes your problem. And as you do need to get the testing done if you're going to rent to families, pregnant women who give birth to children and who have at such a young age are in such a weak state to protect themselves against the dangers that they have no control over. Jack Sparrow was hurt by the Morrisons, and it is time for the Morrisons to pay up for their negligence.
Thank you. Ms. Green, anything you want to add?
Yes, I would just like to elaborate on what I said earlier. We would like them to pay us $5 million. This will help Mr. Jack Barrow mentally and physically. He is not up to date with his regular age. He is not doing well, so we would like the $5 million to help him.
Thank you, sir. All right. Ms. George, this is your opportunity to offer the final words, if you would like.
Your Honor, I'd like to state that when my client bought this property in 1989, lead paint was not even being manufactured. Lead paint stopped being manufactured in 1978, and upon purchasing this property, Your Honor, my client did full renovations on this property. Complete renovations, Your Honor. So, where did he buy this paint? This lead paint, Your Honor? Is there some basement factory that manufactures lead paint? Your Honor, my client purchased this paint from a warehouse store that was not allowed to sell lead paint because it was against the law.
Objection.
Basis of the objection.
Evidence. There's no proof that there was any renovations or that this paint was bought.
That's correct. Objection is sustained. Mr. George, you had the opportunity to present evidence in your case in chief. You did not do so. You cannot provide that evidence now in your closing statement. Go ahead, sir.
Your Honor, the medical records that you have, it does not tie young Jack Barrow's lead paint poisoning to my client's property. Jack Barrow lived in 3 other properties after he lived in my client's property, Your Honor. 3 other properties. And this is 20 years ago, Your Honor. The medical records, they do not state that he had lead chips or lead paint in his blood, Your Honor. The only thing that the medical records actually do state is that young Jack Barrow, who is almost 20 years old right now, has high levels of lead in his blood. Now, that lead could have come from anywhere, Your Honor. Anywhere. Back in the 1970s, Your Honor, there were cars driving around with leaded gas in the atmosphere, Your Honor, releasing harmful, toxic products in the atmosphere. And then when it rained, Your Honor, it would rain right back down on the population. Now, Your Honor, do you think that it is possible that the mother may have acquired lead poisoning and passed it on to her child, Your Honor? The medical records do not state that the child, in fact, did have lead paint poisoning from lead chips from my client's property, Your Honor. And some characteristics of lead paint, Your Honor, that is in bad condition is chipped or peeling paint. And on this property, to this day, there is still no chipped or peeling paint. Now, according to studies done by the Environmental Protection Agency, lead paint that is in good standing condition is not harmful. And even if my client's property does in fact contain lead paint, all the paint on the property is in good standing condition, which means that it's not harmful, Your Honor. That's all I have for today, Your Honor. Thank you.
All right, thank you. Ladies and gentlemen, this is a case that is very disturbing to the court. We're dealing clearly with a now adult who has suffered terrible illness that was due to ingestion of lead. There is no dispute of my having reviewed the medical records that the child does suffer serious injury as a result of that. And I know that the defense has stated that there is a question as to whether there were a distinction between lead paint poisoning and lead poisoning. The court finds that there really is no distinction, that the paint is merely a source of the lead, and if the lead was ingested, as the plaintiff's case did say from the witness who saw the allegation was that the baby was eating chips of paint, then there is a reasonable inference there. So I don't believe that objection necessarily has any merit. And in addition, the defense has indicated that the laws were not in place when the allegation of lead paint poisoning occurred that exists today. And that is true in terms of having the lead certificate that would provide a waiver that did not exist at that time. And while I can appreciate the defendant's concern about the unfairness of it by buying paint that was available at the time, I will tell you that the law does not ignore the fact that someone has been injured. That has been the case with asbestos poisoning, and it is the case with lead poisoning, where the court still finds a party at some point to be liable and responsible for those actions. The defendant did present evidence that there were yearly inspections performed and that there were no evidence from the city of peeling paint, and that is not necessarily dispositive of the case, but it's certainly persuasive evidence of whether or not there is whether there was chipping paint or not. So we now have a conflict between the plaintiff's testimony that a witness saw the child eating paint, but yet the defendant presents comparable evidence that the city did not see it. It doesn't mean just because the inspector did not see it, it didn't exist, but that does create some conflict between the two parties. Notwithstanding my great sympathy toward the victim in this case, however, the law imposes a very strict requirement in the bringing of lawsuits for the very reason that Mr. George has indicated. At what point is someone still going to be held responsible for an action that occurred 20 years ago? And I specifically asked, when was the child residing at the premises? And the child was residing at the premises from birth for 9 months. The question then becomes, where did the child reside after that time frame while still under the age of 1 or even 2 and theoretically subject to the opportunity to consume lead? The parties agree that the child did reside at 2 other residences. There was no evidence as to the condition of those residences at the time. However, by the same token, the plaintiff does have the burden of proof in this matter by a preponderance of the evidence to show that that it occurred at this particular premise and not any other premise. But what particularly causes me concern in this case is the fact we did not establish the actual filing of this action, but there's not clear evidence as to whether this case was filed within the applicable statute of limitations. So the child, the plaintiff is now 20 years of age, and that is within very close to a 3-year period beyond the age of 18. So there, while the statute of limitations was not pled in this case, the court still can take observation of that fact to determine whether the court even has jurisdiction in this case. I do have some questions as to whether the time frame was sufficient within 3 years of the filing, because 3 years from the statute of limitations is told until the child reaches the age of 18, and then the plaintiff has 3 years from the passing of age 18 in which to file the action. The plaintiff turned 18 May of 2011, and this is now September of 2011. We don't know at what point the child, we did not have any evidence. We know it's anywhere between 0 and 9 months as to when the child was alleged to have seen ingesting the paint. So for these reasons, I do find that there is insufficient evidence, notwithstanding my absolute belief that the child did suffer injury, but that the plaintiff has failed to meet its burden of proof in this case, and therefore I do find for the defendants.
We want to show them how to wear the school court banner. In school court they learn how to debate in the best of manners. First they get hired, get a smile from employer, preparing out future business leaders and lawyers. Learn how to fact find info on the back like competitors like football sack time. Whether a defendant or plaintiff, I won't bend, and I will do the best that I can in school court. School court, bang, bang, bang. 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 School.
What interests me the most was how the kids were so articulate in their speeches. They talked so proper and so educated as well. Wow, that was another really great show. I hope you enjoyed it. I'm your host, Ariel Brown, and I'll see you next time.